Assalamu alaikum and welcome back to Just Law on IQRA TV. This is the second part to the show. As our regular viewers are aware, it's a live show. The number that you can call on appears at the bottom of your screen. So please do pick up the phone, call us with any questions that you have on any aspect of the law, and inshallah we'll try and assist you as much as we can. Just before the break, we were looking at the position of those people who have overstayed and really what they can do to regularise their stay in the United Kingdom. We were looking at the position of adult overstayers, and in particular those who have got married or about to get married, and we were looking at the sort of different scenarios that they may encounter in terms of being able to get leave to remain. For example, we've got one category where somebody is getting married to a partner who has British nationality or who has indefinite leave to remain. We looked at their situation, and we were about to then look at the situation of those people who are getting married to somebody who has a European passport. Well, a caller who called about marriage to somebody who is British and who has a child with that person. Obviously that child is British, and I explained that even though just a marriage on its own is not enough, but because of the marriage or because of the relationship there is now a child who is British, that should be sufficient to regularise your stay in the United Kingdom. Now let's now move back to those people who get married to European nationals. And as I said before, by obviously United Kingdom is part of Europe as well, but when we talk about European nationals in an immigration context, it's all the other European countries apart from UK. We'll look at that in greater detail after we've taken our next call. Hello.
Hello, sir.
Hello. Hi.
My question is, what is the spouse visa is time? Because I have applied 3 months ago on the regular fee,
Okay.
but didn't hear anything about it. And what would I do now?
Okay, so in terms of spouse application, are you talking about an application which has been made from abroad, or are you talking about an application made from the United Kingdom?
Made from the United Kingdom.
Made from United Kingdom. Which form did you or your spouse complete when making that application? Can you recollect which form it was?
I don't know. I applied through the solicitor. He did everything.
Okay. I'm assuming, has your wife been here for 2.5 years? Are you applying to have the visa extended?
No. It's the first time. She's in back home.
Or she's back home and then the application has been made. So she would have gone to a visa centre, submitted her passport there?
Yeah.
I understand. Generally speaking, if you don't use the priority service, generally speaking, those applications are processed within about 3 to 3.5 months. So what we have at the moment is basically 2 types of applications which are being made from abroad in terms of spouse visas: a priority application and a non-priority application. The caller obviously was asking about the non-priority application. In my experience, it's generally taken between 3 to 3.5 months to process those applications. Now, there isn't any guarantees in terms of how long it takes. Their service standards, if we call them that, is that applications will be processed within about 12 weeks, but sometimes it does take them longer. My view generally is to wait at least up until 4 months have passed, and if you don't get a reply after 4 months, then to maybe write to them or get your MP to write to them to sort of push this process along. But up until the 4 months mark has been passed, you're better off simply just waiting. The reality is that there's no problem with the application, it's just with the volume of applications that they're dealing with, there's just a delay in processing the application. So at this stage, caller was saying it's been 3 months since the application was submitted. There's nothing to worry about. You might as well wait for another few weeks and see what happens. Now, that's for normal applications, non-priority applications. But where an applicant has paid the priority fee, which is in the region of £600, you do, generally speaking, get a much quicker response. And when I say much quicker, I mean that you generally get a response within approximately 4 to 5 weeks. So you won't get a response within 1 or 2 weeks, as used to be the case many months ago. Generally speaking, the processing time is 4 to 5 weeks. And again, there is no guarantee. If they want to investigate matters, for example, submitted an application, you've shown that there are 2 jobs that the sponsor is doing in the United Kingdom. Now, in that case, the caseworker might say 2 things. It might say, look, what I want to do is interview the sponsor in the UK, and I also want to interview the employer. That is likely to delay matters. The caseworker may say, I want to verify matters with HMRC. That may again delay matters. So there are always certain factors which may mean that instead of your priority application being processed within 4 to 5 weeks, it even takes slightly longer. And what the Home Office says is that we aim to deal with priority applications on a priority basis. So all they mean by that is when they've got, say, 100 cases pending, when your case comes in, all they say is that it will go to the front of the queue. But even when it goes to the front of the queue and the caseworker looks at the documents, the caseworker may decide it's not straightforward as far as they're concerned. They want to look at the financial documents in greater detail. They may want to look at aspects of the relationship in greater detail. So all that then happens is that there is a delay whilst those matters are being investigated. So that is why some cases don't get processed within the sort of time frame that the Home Office suggests. But in my view, if it's a priority application, expect a reply around 4, 5, maybe 6 weeks time. Generally speaking, in about 80% of the cases, they do tend to stick to that. But brother, thank you very much for your call. Hopefully that answers your questions. We are live on air, as I've said before. If you have any questions, do call in and I'll try and address those questions as best I can. Now, going back to our topic for today, the overstayer, but I understand there's another call waiting, so let's take the call and then we'll return to the topic. Hello.
Assalamualaikum.
Walaikum salam. Bhai, thank you for calling. What's your question?
Bhai, I want to ask if someone, basically my wife came on spouse visa.
Ji, okay.
And we have children. So my question is, during 2.5 years, so if my pay is 18,600 and above.
Okay.
So, but can I claim tax credit? And my second question is, if my pay go down less than 18,600, and can I claim tax credit? Will it affect my application visa extension?
Okay.
Visa extension?
All right. Okay. In short, brother, the answer is this. There is no problem whatsoever in claiming working tax credits and child tax credits. And I think we get this question quite frequently. The application is actually made by you, but looked at by HMRC as a joint application. So even when the application is processed and the award is made, both you and your wife will get the award letter. So it looks like it is a joint claim and the payment is being made to both of you. There is no problem at all with that. Now, it may well be that where your income is, let's take for example, your income is £20,000. Depending on the number of children you have, you may qualify for child tax credits. You may not qualify for working tax credits, you may do. But certainly if your income drops, the reality is that with children you will qualify for something. If it's not working tax credits, then definitely child tax credits. That has, there's 2 points there. First of all, it has no negative effect on your application, the fact that you're claiming tax credits. Absolutely no problem with that at all. But the second point I should make is that the money that you get through tax credits, it can't be used as part of your income. So you can't say, well, I earn £15,000 from my job and I also get £3,000, £4,000 from my tax credits. So, combine them together and I meet the requirement. You can't do that, except, there is an exception to that, except where you are in receipt of carer's allowance or disability allowance, and therefore the application is not subject to the 18,600 minimum financial requirement. If you're completely out of that category because you're receiving carer's allowance or disability living allowance, you're out of that 18,600 category. In that situation, you can count your benefits to meet the income requirement, which won't be 18,600. The income requirement is different in that situation. It's, you need to be earning enough money so that you won't have to rely on public funds, and there's a different calculation for that. But in your typical category, what you were explaining, when somebody has to show 18,600, you can't rely on benefits to supplement your income and use that to use the combined income to try and meet the financial requirement. You can't do that. But there's no harm whatsoever in claiming tax credits. And to be quite honest, we get asked this question regularly. And I say this to all my clients and everybody who asks, there's no problem. You declare whatever income it is to HMRC, whatever it is, you show them your wage slips, show them what your income is. And if after they make their assessment, if they say you qualify for tax credits, there is no problem at all with that. You should claim it. It will have no negative impact on your or your wife's application. And we submit applications on a regular basis where people are relying on these benefits. It's never been a problem. The law says it's not the problem. The guidance says it's not a problem. So people should stop worrying about that. I accept that the difficulty arises because the visa that's granted says that you shan't have recourse to public funds, and working tax credits is a public fund. However, the guidance issued by the Home Office is very clear, and the practice is very clear as well, that although it is a public fund, you will not be penalised by making an application for working tax credits or child tax credits. So absolutely no problem at all. If you qualify, by all means make the application. Okay, now just returning to what we were discussing before, which is where an overstayer wants to regularise their stay and they are going to get married or they have got married to somebody who is a European national. Now, there are certain conditions even the European national has to satisfy. For example, they can't just be living in the UK. They need to be what is called exercising treaty rights. Now, what is it, this exercising treaty rights business? What does it mean in reality, in practical terms? It means that they need to be in employment, or they need to be self-employed, or they need to be a student, or they need to be self-sufficient. So they need to be doing something. They need to fall within one of those categories. In reality, what we come across is that European nationals are normally either in employment or in self-employment. If that's the case, fantastic. They are then seen as exercising treaty rights in the United Kingdom. Now, if that's the case, anybody who marries a European national, potentially, once they've got married, potentially they are eligible to stay in the United Kingdom based on that marriage. In practice, the Home Office would grant a 5-year residence card. In practice and in reality, obviously, it's never that easy. There's always complications. The complication that you tend to face where you are going to get married or you have married a European national and you're making this application for a residence card, the complication that you face is that the Home Office views these marriages very suspiciously. In my experience, their starting point seems to be that it's a potential sham marriage. And that being the case, what do? What they tend to do is to interview both the person who's overstayed and making the application to stay here, and also the European national to whom that they have got married. So what they will do is interview both. The idea behind the interview is for them to ascertain whether the marriage is genuine or whether it is a sham marriage or not. Now the problem is, in practice, in my experience, the Home Office, their starting point seems to be that it is a sham marriage unless you actually prove to us, or it's obvious that it's not a sham marriage. Because when people are being called in for an interview, when they want to look at whether the marriage is genuine or not, they're interviewed sometimes for 45 minutes, for an hour. Both parties are interviewed separately. They may be asked 100 questions. And in my experience, what the Home Office tends to do is then focus on the 4 or 5 questions which they say that the parties have got wrong, for want of a better word, where there's been a difference in the account that's been given. So for example, if they've been asked to explain when the parties first met, when they met for the second occasion, and then who gave the other party the telephone number, how the exchange took place in terms of telephone numbers, etc. Maybe there's a discrepancy over that. They may explain quite clearly how they met, where they met, what they did, but in terms of how the relationship developed, there may be a discrepancy. They seize upon that to try and refuse the application. I'll look at that in greater detail after I've taken the next call. Hello, Assalamu alaikum. Ji bhai, what's your question?
I asked the question already. My second question was, I qualify now. I have paid more than 20,000 now, but my wife is more than here in the UK more than 2 years. But last year my pay was less than 20,000. So okay. Is that a problem when I make application?
Okay. When does your wife's visa expire? Can you remember the month when it expires?
Yes, it expires in March next year, but my salary is okay now.
Okay, all right. Now, when somebody is granted a spouse visa, and they're here in the UK, they normally have a 2.5-year visa. It doesn't matter normally what happens in the first 2 years. Where the parties are in employment, what you need to do is look at the income in the 6 months before the application is made. So if your wife's visa is expiring in March 2017, the application would be made in, sorry, 2018, I beg your pardon. Your wife's application would be made in February 2018. So the documents you will be relying on will be September, October, November, December, January and February. So September 2017 onwards, they're the documents, or if you do it much earlier, it's August onwards. So it could be August, September, October, November, December, January, and then make the application in February. It's that period which they're looking at. So even if previously your income was extremely low, you were doing less hours, or you weren't working at all, it doesn't matter.
If you are on benefits,
it doesn't matter. It doesn't matter. You could be on income support, you could be just staying at home, not doing anything at all. It doesn't make a difference. It's in those critical months. And in your situation, August, September, October, November, December, January, the application is made in February 2018. As long as you're earning 18,600, which amounts to I think 1550 a month. As long as you're earning 1550 a month, from then on, it's absolutely fine. You don't need to worry about what's happened in the year before, or even 2 years before. Absolutely nothing, nothing to worry about.
That's great. Thanks for your
no problem at all. Thank you very much for your call. Just on that, just to be on the safe side, so that our viewers don't misunderstand what's being said. Where the parties are relying on employment for the extension application, yes, generally generally speaking, you look at the last 6 months' income. However, there are exceptions to that, or there is more that needs to be said on that. If, for example, you're relying on self-employment, so for example, you decide, I'm going to start a little business. In that case, the income requirement would be your self-employment income in the last financial year. So if an application is being made for an extension in February 2018, what's the last financial year? The last complete financial year is April 16 to April 17, and the application will be made in February 18. That financial year doesn't come to an end, so it's April 16 to April 17. So you've got to be careful that although the application is being made in February 2018, if you're relying on self-employment, then you're going to show income for April 16 to April 17. So you need to be careful that you met the requirements at that stage. Otherwise, you're going to have to not rely on your self-employment income, but you're going to have to rely on your, get into a job and show your 6 months income. My view generally with these things is, if you know that your situation is slightly unusual, the norm is you're earning, let's say, £19,000 a year, you know that for the next year, couple of years, you're going to be on that income, then it's not a problem. But if it's unusual, if you're going to leave a job, start a new job, you might be looking at a bit of self-employment income, or you're going to rely on completely on self-employment income. If it's unusual, speak to your lawyer well in advance, because sometimes it's too difficult to make adjustments right at the end. Speak to your lawyer well in advance, even if need be after your husband or wife is here and it's been 6 months or so. Speak to your lawyer. Ask your lawyer, what is it that you're going to have to show when the extension application is made. In a typical situation regarding employment, it's straightforward, it's the last 6 months. But there are various different scenarios and you need to be prepared for that. What you don't want is that you wait till the end and you realize that whatever that you needed to have put in place, you haven't, and now it's too late for you to meet the financial requirement. And if you're lucky enough to have children, it may well be that the Home Office might not reject the application but put you onto this 10-year track to settlement, which means you're waiting another 10 years before you get indefinite leave. Or if there's no children, there is a real risk that the Home Office looks at refusing your application and saying, look, you've got to go back to your home country and make an application from there. So it's important you get your house in order, so to speak, and get your things in order well in advance so you don't run into difficulties. Now, just going back to what we were discussing, which is where somebody gets married to a European national. And what I was talking about is the general approach of the Home Office, in my view, which is to view these applications very suspiciously, in the sense that they seem to take the view that a lot of these marriages where you have an overstayer is marrying a European national, or non-UK European national, they tend to take the view that they may be entering into a sham marriage because they've overstayed and obviously they want to regularize their stay here. So they will generally be called into an interview, and it's important that during the interview answers which are given in relation to the parties' background, how they met, in terms of the relationship background, in terms of their living arrangements, etc. It's important that consistent answers are given, because if there are discrepancies, the discrepancies will be used against the parties. And what will happen is, in my experience, two things. One is the overstayer, for want of a better word, that person will or could be detained on the basis that the Home Office says that the marriage is a sham marriage. Or secondly, what could happen is that the European national could be threatened with removal from the United Kingdom as well. So it's on the one hand, you're fantastic, you've got a partner, you're going to get married or you've got married, fantastic. Things are now back on track, so to speak. You're going to make an application, you're going to regularize your stay in the United Kingdom. But unfortunately, it isn't as easy as that. Because of the approach that the Home Office takes, there is the potential that if things don't work out properly, things can go drastically wrong. So instead of being out and about, enjoying your married life, the person who's overstayed could find that they have had a problem with the interview and the Home Office is now alleging that it's a sham marriage. They're now going to be detained. And the European national, whoever it is, they're here working away in this relationship, they now find that the Home Office wants to remove them on the basis that they have broken the European regulations. So it's vital in this kind of situation that you do take advice from a competent solicitor who will advise you on the various steps. And if you are unfortunate enough to be detained or threatened with removal, even though it's a genuine marriage, then you have a lawyer who's ready with all the background to your case, ready to try and assist you in coming out of detention. So you shouldn't take this lightly at all. That then unfortunately does bring us to the end of the show. Hope our viewers have found it enjoyable. Inshallah, jazakallah for watching. Assalamu alaikum.